Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. We have a great show for you today. First, Bryan Kohberger's attorneys say the mob will burn the courthouse down when he is acquitted. Derek Chauvin settles into his new Bureau of Prison home. Scott Peterson is still trying to convince people that he is innocent. Robert Tellis trial. Looks like the defendant will testify, and this is going to be good. Airline travel has become the Greyhound bus mode of transportation from the 1980s. A woman was sentenced for killing the man who sexually trafficked her, and then our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below. And yes, make sure you hit that little bell for notifications of when we go live or put up new content. Now, we didn't do a live last night because although you can't see it, there is large amounts of construction going on here. And hopefully all the sanding and painting and hammering will be done shortly. But the home office here has been under construction. So next week, we'll try it again.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado's CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
All right, let's go ahead and get to the docket for August 21st, 2024. And first, Bryan Kohberger. Burn, baby, burn. As you may recall, we brought you the government response in the Bryan Kohberger matter in regards to the motion for change of venue that the defense had filed, because the defense has argued, and they had a hearing on it, and they actually presented evidence as it relates to the survey presented by Dr. Edelman, that there is no way that Bryan Kohberger can receive a fair trial in Latah County. And in fact, the defense in their motion says the pressure to convict Bryan Kohberger is so severe that Latah County survey respondents said if he wasn't convicted, they'd burn the courthouse down. Outrage would be a mild description. They would probably find him and kill him. They would likely be a riot, and he wouldn't last long outside because someone would do the good old boy justice. Enraged, strong opinions, firing of officers, riots, parents would take care of him. This mob mentality, the defense says, within the community is the exact reason that statutory grounds prior to selecting the jury exist to change the venue. The defense says there is no evidence presented by the state to counter Mr. Kohberger's experts who were all clear venue must be changed in this case. The state does, however, acknowledge that Bryan Kohberger has a constitutional right to a fair trial with an impartial jury, so they're pleased about that. And Mr. Kohberger's motion is supported with a memorandum, expert affidavits, declarations, and exhibits that preview the testimonial evidence the court will hear on August 29th. And a rebuttal declaration of a Dr. DeHeer is submitted with this reply. So, defense also says, hey, judge, take note. On June 28th of 2024, the Idaho Supreme Court pointed out that a change of venue is not an unreasonably high hurdle for a defendant to clear, but it does require proof of prejudice or a showing of a reasonable likelihood of prejudice. And the defense says, hey, judge, in this particular case, the Supreme Court in Idaho also said that Concerned with the accuracy of the pretrial publicity, the extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, the number of articles, and whether the jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. So the defense says, just a reminder, Judge, there were more than 1,300 specific media stories covering Latah County, and these stories are in print, digital, as well as on radio and television, and that the coverage conditions the potential veneer panel to think of Mr. Kohberger as guilty, and that various bits of information are factual and support guilt. The media coverage inundated Latah County does not tell citizens that no evidence has been presented at this time, that there are no facts on the record at this time, that Bryan Kohberger is innocent, that only a jury decides what the facts are and whether the facts are beyond a reasonable doubt. The state went on to criticize the work of Dr. Edelman and the defense states specifically. The defense notes that the survey done by Dr. Edelman justifies a change of venue. In their motion, they state the state's claim about these surveys are wrong. Dr. Edelman designed the survey questions and how, depending on the participants' answers, the order of questions would flow. The survey report lays out the questions and responses for all counties and demonstrates that the survey was conducted exactly the same way in each county surveyed. The only difference is the number of participants. The state further criticized the survey by the defense, asking the court to disregard it entirely, alleging the survey did not include record of citizens in Latah County who did not want to participate in the survey. This assertion is incorrect, the defense argues, and specifically the last page of the survey report provides a table depicting the total amount of numbers dialed and what happened. In support of its argument, the state cites the court to a study done by the Pew Research Center. However, only a partial statement from the study was included. Dr. Veronica Dahir has reviewed the survey done in this case, as well as the objections filed by the state. She opines that any response rate does not create a bias or invalidate the survey. The survey conducted by Mr. Kohberger's case is unrefuted and is reliable. And the doctor prepared an affidavit which is attached to this particular motion. And so what this goes down to, ladies and gentlemen, this motion for change of venue should be granted. I think it's a no-brainer in this particular case, but particularly in light of the evidence that's been presented and will be presented is that here's the final results of the survey. The judge gets to hear Dr. Edelman testify on the 29th when they have this hearing. And the state has nothing to refute it other than what they put in their response, which was frankly quite weak. All right. And yes, it would be nice if it gets to stay there. It's going to be cheap to do the trial. Let's face it, that courtroom is not big enough. If you've seen the Latah County courtroom, it's not big enough. There's no way. And the county commissioners, get the checkbook ready because you are going to have to pay for all these services, and it's going to happen. So get used to it. Anyway, the motion filed by the defense states that the state's proposed remedies expanding to Nez Perce County, vetting the sequestration are not valid remedies. And they said expanding to another county is not a remedy because the residents of Lewiston and Nez Perce are in the same designated market area of Latah County, and they have been exposed to the same excessive media coverage. And they go on to note that vetting as proposed by the state does not work. For decades, the court have recognized that simply because a jury of 12 can be selected does not mean that the jury is impartial, right? The requirement of the law is not satisfied by the mere impaneling of 12 men and women against whom no legal complaint can be made. The defendant is entitled to be tried in a county where a fair proportion of the people qualified for jury service may be used as a veneer from which a jury may be secured to try this case fairly and impartially and uninfluenced by a predominant sentiment that he should be flung to the lions. And they cite a case, State v. Seal, a 208 Mississippi case back from 1950, but it's still a good summary of the law, that's for sure. And although they said, there's a way we can mitigate this, and basically it says, just give everybody the presumption of innocence, it's not gonna flow. So anyway, in conclusion, Mr. Kohberger provided this court with an extensive and unrefuted evidence. The evidence includes proof of excessive media coverage in Latah County that is both prejudicial and false, along with declarations of experts explaining why remedies other than a change of venue are not enough. The evidence will be further developed at the change of venue hearing, and the traumatized town of Moscow is understandably filled with deeply held prejudgment opinions of guilt. The surrounding area of Nez Perce County and Lewiston are not situated differently. The issues of venue reach finality with a change to Ada because the Latah County mob mentality will never produce a veneer that results in a cross-section of the community. Now, I think it's also interesting, in the exhibits that they attached, they basically said the people that did not recognize the case in Ada County are 67% of the people that were surveyed. That's rather interesting, to say the least. And there are some other attachments along with the experts. But the biggest thing on the defense side here is that they're the only ones that produced any evidence, and they're going to be the only ones that produce any evidence. The defense hasn't been given notice that there's going to be an expert by the prosecution. There's been no endorsement that I've seen. So they don't have anybody to say, hey, this is so flawed, the process, the survey. I'd be very surprised if there was not a change of venue in the Bryan Kohberger case. And hey, if not, the mob is going to get him there in Latah County, because they can't understand that a jury apparently can find somebody not guilty, apparently, in Latah County. I don't know. I don't think the people in Latah County when we were there were a bunch of country hayseeds. They seemed all very nice and responsible, and I think they would respect the jury decision. But unfortunately, the prosecution has dropped the ball again on this one, ladies and gentlemen. They don't have their own expert to refute this. I think it's going to get changed. Next on the docket, Derek Chauvin settling into his new abode. That's right, Derek Chauvin. Remember him? Remember that guy? The former Minneapolis police officer convicted of killing George Floyd was transferred to a federal prison in Texas almost 9 months after he was stabbed in a different facility. Now, Chauvin is housed at the Federal Correctional Institution in Big Springs, a low-security prison. He was previously held at an FCI facility in Arizona when he got sentenced back in August of 2022 to serve a 21-year federal sentence for violating Floyd's civil rights and the 22-and-a-half-year state sentence for second-degree murder. Now, the transfer comes 9 months. Can you believe it's been 9 months since Chauvin was stabbed 22 times in prison by a former gang leader and a one-time FBI informant? Now, another former Minneapolis police officer, Thomas Lane, who laid on Mr. Floyd's leg as the man struggled to breathe, was released from federal prison in Colorado on Tuesday. And the Bureau of Prisons also says that Officer Lane was serving a 3-year sentence for aiding and abetting manslaughter. Now, when Lane pled guilty, he admitted that he intentionally helped restrain Floyd in a way that he knew created an unreasonable risk and caused Mr. Floyd's death. He admitted that he heard Floyd say he couldn't breathe, knew Floyd fell silent, had no pulse, and appeared to have lost consciousness. And can you believe it? It was already back in May of 2020 when Floyd died after the notorious neck kneeling by Chauvin as it relates to Mr. Floyd. Anyway, also have Officer Alexander Koenig, who is black. He knelt on Floyd's back, and Officer To Tao, who is a Hmong American, and he kept bystanders from interfering during the 9.5-minute restraint. Now, Koenig and Tao are both set to be released in 2025. Koenig is detained in a federal facility in Ohio, and Tao is in a facility in Kentucky. Like I said, Lane was one of the first of the 4 officers convicted of the crimes related to Floyd's killing. Now, don't forget that Derek Chauvin is making a bid to overturn his federal guilty plea, claiming that there's new evidence that shows he didn't cause Floyd's death. And obviously, if he's unsuccessful, he'll be eligible for release in about the year 2038. Now, it's going to be difficult. I don't think I've ever seen a federal guilty plea withdrawn. I know there's lots of people and making its way around the internet that Floyd died of fentanyl overdose, as well as possibly a sundry of other issues. And that wouldn't surprise me. I think the defense actually put forward a pretty good defense that basically said that George Floyd had a fentanyl overdose. However, the jury rejected that. And so therefore, when he was convicted and sentenced to his 22 years in the state sentence, Chauvin made a deal. He pled guilty, and he desired to serve his time in federal custody versus in state custody. Well, it didn't quite work out so well for him because he got stabbed 20 some odd times. But I find it to be very unlikely that he's going to be allowed to withdraw his guilty plea. He knew that case inside and out. He knew what the consequences were, and he'd already lost once. So we'll have to watch that and see how that comes out. Now, the guy that did the stabbing is a guy named by the name of John Tursak. He is serving a 30-year sentence for crimes committed while he was a member of the Mexican Mafia prison gang. And he was also charged with attempted murder of Mr. Chauvin, and he told correctional officers he would have killed Chauvin had they not responded so quickly. He had told investigators that he targeted the ex-police officer because of the notoriety for killing George Floyd. Well, there you go. There you go, ladies and gentlemen. See, prison can be a dangerous place. Dangerous place. I think Mr. Chauvin will be there the rest of his days. I don't think they're going to allow him to withdraw his guilty plea. If he thought he was innocent, he should not have pled guilty, okay? Innocent people shouldn't plead guilty, particularly to something that's going to result in decades of prison time. We're not talking about a simple speeding ticket and you plead guilty to a defective headlamp. We're not talking about the same thing. He pled guilty to violation of his rights, civil rights. You don't do that unless you're actually saying you plead guilty. And when you do plead guilty, you admit as a matter of law and as a matter of fact that you are guilty. And then it's disingenuous to come back and say, oh, never mind, I didn't mean it. Speaking of some disingenuous people, let's talk about Scott Peterson. He's got a new theory of his innocence. It's been floating around for a while. Well, I don't think it's going to work. So nearly 2 decades after Scott Peterson was sent away for the murder of his pregnant wife, he's back. He's back with a new theory that he hopes could possibly clear his name. And Scott Peterson has given his first on-camera interview on the Peacock Network in a new documentary titled Face to Face with Scott Peterson. Obviously, since he's been sentenced to life without the possibility of parole after the death sentence was overturned. And that was in regards to the death and murder of his wife, Lacey Peterson, and their unborn son, Connor. Now, Peterson is adamant that he didn't kill his family. He said burglars did it. Burglars in Modesto, California did it. And burglars led to his 8-month pregnant wife's disappearance. He alleges that there was a burglary across the street from the home. Now, this is not anything new, ladies and gentlemen. This has been out there for a long time. But Peterson claims that during a video interview inside the Mule Creek State Prison, he believes that Lacey went over to see what was going on and that's when she was taken. Now, as you may recall, Lacey vanished on Christmas Eve in 2002, and her body washed up in the San Francisco Bay months later in April. Her unborn child's body was found not far from hers as well a few days later. Now, Peterson is pointing the finger at investigators who claim they didn't turn over all the evidence to the defense in this case that possibly could have cleared him on his wife's murder during the murder trial. Now, there were so many instances where there was evidence that didn't fit the detective's theory that they ignored, Peterson alleges. People want the answer they believe in to be the answers. In this interview, there's also interviews with journalists that covered the trial, legal experts that share that witnesses reported to police that a suspicious van was in the area and that homes were burglared on December 24th of 2002. There's even a witness or two allegedly claiming that they saw a pregnant woman being forced into a van. However, 2 former Modesto police detectives, John Bueller and Al Brocchini, are discrediting Peterson's claim, saying there's absolutely no new evidence that would absolve the convicted killer of the murder of Laci Peterson. Now, Peterson does state that he regrets not testifying at his trial, is now speaking up for his family, who has obviously been behind him all of these years. And he said, if I have a chance to get the reality out there, I have to take that chance to show people what is the truth and if they're willing to accept it. Maybe it takes a little bit of a hurt for the family, but Peterson says that the biggest thing he can do now is he can accomplish right now is to get the truth out there. Now, his sister-in-law, Janie Peterson, also strongly claims in the opening of the documentary that she believes her brother-in-law, Scott, has been wrongfully convicted of the murder. And as you know, the Los Angeles Innocence Project, not associated with the Innocence Project, took Peterson's case back in January, arguing that new evidence would show he did not commit the murders. Peterson obviously admitted that he was having an affair during the time that his wife went missing and, had the boat and, maybe wasn't aware that the police were tracking him and knew that he was watching them search the bay. I don't know. Anyway, his family's still supporting him. A lot of other people are not. Now, we don't have to give Scott Peterson the presumption of innocence because he's been convicted. He's gone through appeals. He's gone through post-conviction. And now they're trying even more items of post-conviction. But I do truly believe that Scott Peterson is guilty. All right? Let me know if you disagree or agree with me. But sometimes you got to just go, at some point, you got to realize it's over, man. It's over. Like I said, he was sentenced to death by lethal injection, but the Supreme Court overruled Scott Peterson's conviction back in 2020 because of juror misconduct. And don't get me started on juror misconduct. Maybe he should have been entitled to a new trial just because of the juror misconduct, but the Supreme Court kind of split the proverbial baby and said, well, we're not going to give you a new trial because we think you're guilty, but we'll take away the death penalty. Now will you go away? No, he's still not going away. Next, the Tellis trial. That's right. So for the last 2 years, Mr. Tellis, from behind bars in the courtroom, has told everybody that the former Democrat elected official says that he is going to tell his story to the jury, and that will decide whether he goes to prison or goes free after he's alleged of killing an investigative journalist who wrote articles critical of the politician and his workplace conduct. So on Wednesday, that's today, the defendant, Robert Tellis, gets his chance. Now, he has said he is going to tell his story, and we anticipate that telling that story will take place today. And his attorneys stated that the hearing, which Tellis told the judge handling his case that he has no obligation to testify. And with the jury out of the courtroom, this was all explained. The judge explained to Mr. Tellis whether he understood the risks about whether he wanted to risk answering questions under oath from the prosecution who had rested their case after 4 days of testimony. The prosecution presented 28 witnesses and hundreds of pages of photos, police reports, and video evidence against him. Mr. Tellis was told by the judge, you understand, you've heard all of the evidence that the state intends to present in this case. The judge asked him, and you understand that you cannot be compelled to testify in this matter, right? You understand that? Anyway, Mr. Tellis said that he did, and guess what? Anyway, Mr. Tellis then responded, yes. Now, the attorneys for Mr. Tellis and his co-counsel outside the courtroom advised Tellis against testifying, but he has insisted. The defense may call 3 other witnesses, according to the attorneys, who might corroborate Tellis's account that he visited a local membership gym the day of the murder. Now, Tellis is expected to be the last person called in a defense case. No family member or character witnesses are scheduled. I mean, unless they have some factual information, nobody cares about your character. It's not about whether you're a good person or a bad person. It's about whether the facts took place as charged. That's it. So anyway, although his attorneys have said don't do it, he's entitled to present his defense. And this is the defense apparently Mr. Tellis wants to represent. Now, Mr. Tellis is an attorney, apparently with no experience in criminal law whatsoever. But hey, how tough could it possibly be? And he says that he didn't kill the Las Vegas Review-Journal reporter, Jeff German. But when asked over the years where he was when all that took place, he could provide no good answers. The defense team called 2 witnesses Tuesday. A clinical and forensic psychologist testified about the slashes found on Tellis's wrists when he was arrested at home by the Las Vegas police, and that should not be interpreted as a sign of guilt of consciousness. Oh, you mean when he tried to kill himself? Anyway, in response to questions from the judge, the expert witness, Mark Chambers, acknowledged that such wounds could have been an attempt to draw sympathy. Also Tuesday, a woman testified that she called police to report what she thought was a person seen on video. News reports wearing an orange outfit walking near German's home resembled someone she saw at a park a few days before the killing. She did not identify Mr. Tellis in court. Now, there's been a lot of evidence presented against Mr. Tellis. His DNA was found beneath German's fingernails. That's a problem. He had family ties to a maroon SUV seen in German's neighborhood about the time that German was killed. Another bad fact. Police found on Tellis's cell phone and computer hundreds of photos of German's home and several pages of German's identity records, including timestamps showing they'd been collected just weeks before the killing. Kind of shows some premeditation, doesn't it? And at Mr. Tellis's house, police found cut up pieces of the broad straw hat and gray athletic shoes that looked very similar to those worn by a person captured on neighborhood security footage wearing an oversized orange long-sleeve shirt, carrying a big cloth satchel, and seen slipping into a side yard of German's home before the reporter was ambushed and left to be found in a pool of his own blood. Robbery wasn't an apparent motive for the killing, the prosecutors alleged. The jury also learned that German's wallet, money, car keys, and cell phones were still in the pockets of his shorts. Nothing was amiss in German's home, although his garage door remained open, to the puzzlement of his across-the-street neighbor, who sobbed on the witness stand, saying they remembered finding the body the next day. Now, neither an orange shirt nor a murder weapon was entered as evidence, and prosecutors alleged that Tellis was motivated to kill after German authored articles in the Las Vegas Review-Journal about a county office in turmoil, including allegations that Tellis had an inappropriate relationship with a female co-worker. Tellis lost his bid for re-election as the Clark County Public Administrator, and the Guardian and derided German and the newspaper on social media. Now, Tellis complained that he was being victimized by a political and social old guard real estate network for trying to fight corruption that he saw in the office. Now, a police intelligence unit detective who was investigating those allegations, Derek Jappy, also became a key figure in Tellis's arrest several days after the killing. Now, through questions of the prosecution, witnesses had shown that Tellis believed Jappy shaped the murder investigation against him. And quote, "I am about nothing but justice, fairness, and just being a good person," Tellis told German in an audio interview aired with a May 2022 Review Journal article about the public administrator's office. "It's unreal the length that they're going to try and ruin my personal life." Now, German spent 44 years covering Las Vegas mobsters and public officials at the Las Vegas Sun and then the larger Review Journal. About 10 of his family members and friends have attended each day of the trial, and they have declined to speak to the media. We'll have to see how that goes. He'll probably have testified, but we'll bring it to you tomorrow if it's a complete mess that takes place. Next, air travel has become the Greyhound bus form of transportation from the 80s. Please meet Eugenio Hernandez Garnier and Yusilindis Blanco Loya. Well, they were arrested on Monday at the Miami International Airport after boarding an American Airlines flight with service to Las Vegas. Now, according to police, Mr. Hernandez Garnier was bleeding from his forehead after boarding the plane and had a bandage wrapped around his head. He allegedly asked to clean up the blood and replace the bandage, but he said he didn't have any clean bandages. He was then allegedly asked multiple times to deboard the flight due to the fact that he was bleeding from his head and that the crew members were concerned about his medical condition and the blood contaminating the airplane and people around it. He and his companion, Miss Loya, however, refused to comply and allegedly said if they could not fly no one else can fly either. That's when the police responded to the scene and allegedly told the pair that they would be arrested for trespass after warning if they refused to comply with orders to get off the darn plane. Well, and of course, that's what happened. They refused. Loya then went live on TikTok during the incident and can be seen telling officials Hernandez Garnier recently had some sort of operation. That, however, wasn't an excuse enough to allow them to stay on board. Now, according to the police, the two absolutely refused to comply to leave the airplane. And after a brief moment of resistance to be handcuffed, they were subsequently placed under arrest. The plane also had to be completely cleared out, which its authorities say caused unnecessary delays to the airlines to over 100 passengers on the plane. Of course, the two had to be taken to the hospital, at least the one did, due to their bleeding condition before going to jail. They faced charges of trespassing after warning and resisting an officer without violence. The cause of bleeding, nobody really knows as to why. Anyway, of course, American Airlines made a statement and said because customers became disruptive and were not compliant with crew members' instructions during the boarding, they added law enforcement responded and removed both customers from the aircraft. And we praise our crew and the professionalism of everybody. And why can't everybody just do what they're told when you get on the damn airplane? Seriously, ladies and gentlemen, I got zero tolerance for misconduct on airplanes. I just hate it. And it's like, it just drives me bonkers. Why can't people just behave? Don't get drunk. Just sit there. Most of the flights are no more than a couple of hours. You can make it without packing up the entire kitchen sink, including with your little neck scrunchie, for that 2-hour flight. I don't get it. And remember when people used to dress to go on an airliner? Yes, dress. It was a big deal. Now it's become like traveling on a bus. Next, a woman has been sentenced for killing the person who sex trafficked her. So the 24-year-old woman will spend a decade behind bars for fatally shooting a 34-year-old man who reportedly molested and sexually trafficked her when she was a teenager. Now, Crystal Kaiser received a sentence of 11 years of confinement following by 5 years of extended supervision in connection with the death of Randall Villar. Now, she pled guilty to second-degree murder, reckless homicide back in May. Now, prosecutors argue that back in 2018, Kaiser, who was 17 at the time, fatally shot Villar at his home before setting his house on fire and stealing his vehicle. She initially faced charges of first-degree murder, intentional homicide, arson, car theft, and being a felon in possession of firearm. Kaiser reportedly met Villar on a sex trafficking website, and he had molested and sex trafficked her. Now, Kaiser informed authorities that she shot Villar when he had attempted to touch her. Now, records show that Kaiser bail was initially set at $1 million back in June of 2018, later decreased to $400,000 back in February of 2020, and multiple groups helped fundraise for the bail. Over 1.5 million people also signed a petition that was circulated online to have the defendant's charges dropped. Well, Kaiser argued that she was legally permitted to kill Villar because he was sex trafficking her. And back in 2022, the Wisconsin Supreme Court ruled that a 2008 statute that pardons trafficking victims of criminal liability against their traffickers includes first-degree homicide. However, the court said they needed evidence proving that the fatal shooting was directly correlated to being trafficked. Investigators learned originally Villar was allegedly abusing multiple underage black girls prior to his death. Authorities arrested him in February of 2018, and he was charged and released without bail. Now, the Kenosha County Judge Wilk, sentenced Kaiser and said that the court is well aware of your circumstances surrounding your relationship with Mr. Villar. You are not permitted to be the instrument of his reckoning. To hold otherwise is to endorse a descent into lawlessness and chaos, which is basically you can't have vigilante justice. Now, a lot of states have passed these immunity laws for victims of human trafficking and basically said that they get immunity for everything that they've done during that time, but it has to be related directly to the sex trafficking, like go rob this bank, go shoplift here. those type of things. Interesting argument that she made in this particular case. It said, hey, this guy was sex trafficking her. I was being sex trafficked, and therefore I can kill this guy to protect myself. But it's a little tenuous, but there were certainly mitigating circumstances, hence the reason for only an 11-year sentence, which you have to admit is pretty low. People who get sentences like that usually have been, abused of Munchausen syndrome and go on to become social media stars, I guess. But anyway, this case is a little more deserving of that sentence indeed. And then finally today, our dumb criminal of the day. A Chicago woman was arrested at an Indiana Applebee's after an argument occurred over the all-you-can-eat deal that Applebee's was offering. So Shanisa Cobb was charged back in August with disorderly conduct, back in August 2nd of this year. So apparently about 8:38 p.m. on August 2nd, the Portage police officers responded to the Applebee's Bar and Grill as a response to a reported disturbance. When the officers arrived, they heard several people yelling and screaming. A woman spoke to the police and said she, along with Cobbs, another man, and several children, were involved in the argument with the Applebee's manager. The group was under the impression that if they ordered the $15.99 all-you-can-eat deal for one person, the order was good for the whole table. Now, when the group was told that the price would be for each person to pay the $15.99 special meal, that's when the argument started. Now, the group said the manager was unprofessional and that nowhere on the menu did it say $15.99 was per person. Well, Ms. Cobb then handed the menu to the police, who showed both Cobb and another woman in the group and said per person on the menu. At that time, a couple was leaving the restaurant and Cobb pointed at them, stating that words had been previously exchanged between the couple and the group. After the couple walked out the door, words were exchanged again, and Cobb allegedly became very loud and disorderly. Police warned Ms. Cobb that if she was being disorderly, and one of the women in her group tried to calm her down. Well, when that didn't work, the police told Ms. Cobb that, again, that she was going to be disruptive, that she was going to be arrested. Well, then she was put in the police car and taken to the Porter County Jail. And guess what? Ms. Cobb got arrested for that, and then her group finally paid the bill for $15.99 per person. Ms. Cobb, you are a dumb criminal of the day. It's per person. All you can eat is not per table, per family. It's per person. Ms. Cobb, that's just dumb. Dumb. Anyway, that's all we have for you today, ladies and gentlemen. Thanks for joining us. We appreciate you taking the time to be here, and we'll see you tomorrow. And remember, the Constitution matters.